Mr. Speaker, sir, guidelines on disclosures involving ministers, basically, we have to judge the situation. In this case, CPIB judged, and I supported them, that they are going to be interviewing a minister. They're going to be interviewing other people. Word will go around town. It's untenable for us to say we have no comment. And therefore, they put out a statement that they are interviewing the ministers, a minister. There have been, and it is not the previous precedent. Those of you who are old enough to remember, I don't think there's anybody else in the House except me who was here when Mr. Tee Chiang Wan was investigated. And none of that was announced. Because you don't know at first when you interview him whether or not there is something there. And if you interview him, if you announce that he is being interviewed, Minister for National Development, and then it turns out there's nothing there, and you come out 3 days later and say Minister for National Development is innocent, I think you're going to cause great consternation, and in the end of that, his reputation will be damaged undeservedly. But you investigate him first. If it turns out there is something there, at some point you cross a threshold and it is necessary to make an announcement. In this case, CPIB judged that the threshold to say that they are talking to Mr. Iswaran was there right from the beginning, because they were going to call in other people, including Mr. Ong Beng Seng, HPL. Therefore, it was not possible for this thing to be kept quiet, and it had to be stated up front. But would they know where the investigation will lead? At that point, no. 3 days later, after interviewing different people and establishing various facts, they make a fresh assessment. At that point, they are comfortable to say that the minister was arrested and bailed. Because the situation is different. So these are operational judgments which our law enforcement agencies have got to make. All the law enforcement agencies, whether it's CNB, whether it's the police, whether it's CPIB, and they do this all the time. And in this case, CPIB did it. And did they know that 3 days later, Mr. Ong Beng Seng would issue, HPL would issue such a statement? I think they expected that that HPL would have to issue such a statement because there's a regulatory requirement by the SGX. I don't think they would know what Mr. Ong Beng Seng would say, and it would depend what had transpired during the 3 days before Mr. Ong put out that statement. So I think we are reading a lot into very little. First of all, nobody knew that Mr. Iswaran might or might not have been doing something wrong. CPIB found out. Nobody tipped them off. Nobody blew a whistle. Nobody raised a public scandal. No PQ in Parliament, not even from the Workers' Party. But CPIB found out, and they told me, and they decided to investigate the matter. And they proceeded. It reached a point where they needed to interview the minister. And then they came to tell me and say, can I have your concurrence? Because CPIB reports to somebody. It has to report to somebody. It can't report to God. So who does it report to? Now, that's a very interesting question. Once upon a time, we had an SAF officer who went overseas on a course. He went to a Commonwealth country. And the course mate asked him, how do you keep your system clean in Singapore of corruption? This is a country which grapples with this problem. And he gave explained how we do it. You know, we have the CPIB, it was zealous, it has a fearsome reputation. You go and lim kopi, you know what will happen. And his course mate asked him, whom does the CPIB report to? So he thought this was an organizational question. So he said, well, you know, it's independent, it's got its own chain of command, it reports to the Prime Minister. And his colleague looked at him again and says, whom does the CPIB report to? Why did he ask that question? Because the question at the root of it is the age-old problem. Who is to judge the people who judge the people who judge the judges? Who is in charge? Somebody has to be in charge. And in Singapore, the Prime Minister is in charge. And if he is corrupt, you are sunk. But beyond that, we decided to put in an extra safeguard. And that is, if the Prime Minister directs the CPIB, you don't do that. CPIB can go to the President and say, Prime Minister has refused me consent, do you concur? And if the President says yes, then the Director CPIB can proceed. If the President agrees with the Prime Minister that the Director CPIB does not have a case or has gone rogue or is doing something ill-founded and says no, well, that's how two keys work. And therefore, the matter stops there. Is it guaranteed? No, because the Prime Minister may be corrupt, the President may be mistaken, but it's as best it is possible to contrive a system with human beings which will work, provided you put honest people in charge. That's how the system is supposed to work in Singapore. Now, as for the interdiction and why it's $8,500 per month, we considered this carefully. We are not the first. It's unusual for a Prime Minister to have to do this to a minister, but we are not the first organization to confront this problem of a person under suspicion being investigated. And what do you do with him while he's being investigated before he's either cleared or charged and convicted? You have to have some arrangement. Can you leave him at work? Well, that depends. In the case of the ride-out bungalows, I had no doubt I could leave the ministers at work. I did not believe that they were guilty, neither did any evidence come up during the process of the investigation that they were. In fact, the investigation cleared them. If the investigation had surfaced something which looked questionable, I would have been told, and I would have made a decision whether they needed to be interdicted and put on leave of absence. In the case of Mr. Iswaran, by the time formal investigations began on the 11th of July, the CPIB had been working on this case since at least May. So they had some basis to come to some conclusion, and I had to decide what to do with a minister who's being investigated for what could be quite a serious matter, which is a possible corruption offense. That's why CPIB is investigating it. And what do I do? Because I don't have a precedent, I don't have a norm, I look at what the civil service does as a guideline. Their situation is different, but here you have an officer who is under suspicion, who is under investigation. He has not been convicted. A presumption of innocence applies. He is innocent until proven guilty. So I could technically have said, well, presumed innocent, he goes on leave, full pay until the matter is cleared. I could also have said, there's a cloud, I straight away don't want anybody with a cloud, you're out. I think that would have been unjust because he has not been charged, the case has not been, if there's a case, the case has not been heard, he's not been found guilty or acquitted or whatever. I cannot prejudge a case based on an incomplete investigation started recently, or a partial investigation just entered into the formal phase. So what is a fair thing to do? And the civil service, their practice is, in such situations, you get interdicted, you're put on half pay, subject to a ceiling and a floor, but you are there until the matter is disposed of. If you are, at the end of it, innocent, if nothing is there, your back pay is reinstated to you and made good. If later on, in fact, you're found guilty, well, at that point, your pay will stop completely and other consequences will follow. And I think that is a reasonable model to follow, and that is the basis on which I decided that Mr. Iswaran would be interdicted and that he would be paid $8,500 per month instead of his normal salary. And he was told, acknowledged, and that was done. I think that's the proper way to do things.